can you please get clear references about what you're asking about, what was said?
You
what
stated, I don't believe I have violated the behavior order since in that manner, right? Good morning, Your Honor.
Good morning.
We're on the record. Perfect. We're on the record. This is Dee. Good morning, everyone. Mr. Jimmerson, your appearance.
Good morning, Your Honor. James Jimmerson, bar number 12599, on behalf of plaintiff, who is also present on my right.
Good morning.
And we have our law clerk, Andrew Pastor, participating remotely, Your Honor.
Okay, via Zoom. Got it. Mr. Page, your appearance.
Good morning, Fred Page, number 638, here on behalf of is present with me.
Okay, good morning. All right, everyone may be seated if you like, particularly the clients. I know there's a couple of pretrial matters. I did review this matter this morning, and I note that we have an objection to the media request. We have a response by our Nevada judges. I note the presence, good morning, in the courtroom, so we can handle that one. And then Mr. Jimmerson filed a proposed findings of fact and conclusions of law. So I have that as well. Okay, regarding your objection to media presence, I of course reviewed the objection. As far as your pleading goes, Mr. Page, would you like to add anything or present argument?
Yeah, briefly. There are some more salacious things that go into this, which may make it more tabloid-like as far as their desire to be in here. For example, Ms. father has had some involvement with the Nevada Gaming Commission for various things that's happened over the years. That may make it more salacious as to why they want to be here today. Again, we're talking about, in large part, a child, and this child should be protected from things that are going to go out in the universe. Once they go out in the universe, they can't be brought back. You can't unring the bell in that regard. I think anything that could damage this child as it comes from either parent would be just awful, and it has really no place in being out there in the public realm, particularly when we have people who are well known in this town that would be of interest just so somebody can make money off of the name itself and the incidents involving these people. Therefore, I think there's no compelling reason why communication between these parties, dealings with these parties regarding their child should be out in the public forum. And for that, I think, for that reason, I maintain that the case should be sealed and our Nevada judges should be not permitted to record the proceedings. That does need to be out there in the world. Thank you.
Okay. And Mr. Jimmerson, do you have any?
I would simply respond as follows, Your Honor. My client does not take a position. We've not filed anything as part of this briefing. However, we would highlight a couple things. Number one, the defendant does not have any standing to assert any sort of protection on behalf of my client's father or the last name. And so any arguments on that basis should be rejected. Obviously, this is a private matter, as are all family court matters. However, as we are now learning from the Nevada Supreme Court, that exposure, of these sorts of proceedings, in this case a trial, is what the public has an interest in ensuring that there is a fair administration of justice. And so while we certainly believe these are private matters, we don't take the position that they should be closed to the public, given how many other prior proceedings have been filmed, and given that we've been working towards this particular trial. It would be curious indeed if the public got to be exposed to all the events leading up to the trial, but the most important event isn't exposed to the public. And to the extent that I can speak on behalf of, or to the extent that I can speak to the effect it has on the parties, at least my client, my understanding is that the names of the parties are effectively redacted, and that all we see are the actions of the court, the actions of the advocates, and how the court goes about doing its business, free of the identification of the particular individual involved. If I'm wrong, I'm happy to be corrected, but that's always been my understanding.
My
you
client,
rebuttal?
my client indicates to me that both my client's name and plaintiff's name came into the record at the 40-minute mark of one of the prior hearings. So that's, so if they're gonna say they're going to keep the names out of it, that just didn't happen. Plus my client indicates that at one of the prior hearings, that his HIPAA protected information could be seen on the video screen. So that's out there in the universe as well. For those reasons, in addition to the reasons that I indicated before, we respectfully request that the matter be sealed and that they be prohibited from making the matters here public.
Thank you. I am ready to rule on this matter. Well, first, let me just address the factual arguments. I was surprised to see the objection come just yesterday. The timing was surprising, but also because the parties have not objected thus far to media being present, and defendant particularly noted on the record at a prior hearing when we addressed this before we got started, the first date that our Nevada judges were present in the courtroom. I particularly asked the party if they wanted to know any objection, and I believe there's filings noting that there were no prior objections to this, but it was your client, Mr. Page, the defendant, who particularly agreed to have media present. He even noted on the record that there was a prior conflict with a prior counsel who has, I'll say, objected to media requests in the past, and that he wanted and did not mind and welcomed the media here. So that's just factual about why I was surprised to see this, and the timing is interesting going forward. I will say this. I know the argument has been made time and time again that in divorce matters, family matters, they're private, right? A lot of information comes into play that parties would prefer to have private. However, there are alternatives to having a trial in a public forum. Our Nevada Supreme Court has been very clear that these courtrooms do not belong to us, they belong to the public. I'm just assigned to sit here temporarily until that assignment changes. So I truly believe in the policy behind the decision, the Falcone decision, that the public has a right to observe what we're doing. There's a big concern in our community about backdoor deals or just a lack of understanding of what actually happens in trials. We know a lot of matters resolve. I also want to note that Mr. is not a party to this case, and this argument is also interesting because there was a hearing where Mr. was actually present as an observer and there was no objection at that time. So I do note that in the pleading, it's discussed that the compelling reasons that this evidentiary hearing involves a minor child. Every custody matter involves a minor child. There are exceptions and more restrictions placed on media when we have particularly sensitive information, of course, child abuse, particularly sexual abuse, when we have child witnesses. We've discussed a lot of these issues before, and it's my understanding that we have the parties' testimony primarily, and these are primarily contempt allegations about the parents, and we don't have child testimony, we don't have those types of concerns. I will note, and I will ask our media that's present right now, that if there is a way, and I know, sir, you said that you saw this, so I have no reason to doubt that maybe you were able to ascertain the party names and some information. I would ask that the media make sure that the names are redacted. I've only seen a couple of clips of videos, and it's usually initials and difficult to ascertain who the parties are, and a blurb over the parties' faces, and the focus is primarily on counsels and the court and the decisions, and more from an educational perspective with little blurbs about what legal terms mean and that sort of thing. But by all means, I want to make sure that the parties are protected as far as their identities, and particularly for the sake of the subject minor here, that her name is not released. And please make sure to check those redactions before this video is released. Again, our Supreme Court has made it very clear that we're to find the least restrictive means when it comes to any type of closure here. Because we have a minor child and the parties' names are popular in family court, that's what tends to happen, right? You have known names and then media shows up. Also, I'll note, in the criminal realm, my background, we're just used to the media being there. The public interest outweighs the balance of the parties' request for privacy in these matters. Again, we're in a public courtroom and the parties had the option for private mediation or arbitration. They chose to be here and avail themselves of our county courtroom, and so the media can stay for the public benefit of the public interest. Okay, so the request to have the media excluded is denied at this time. That matter is handled. Mr. Page, I didn't know if you had anything you wanted to add about the findings and fact conclusions of law that was submitted. Of course, it's just proposed. I'll note that I have not taken an ounce of evidence yet, but that was filed early this morning from the plaintiff side. And I didn't really review it either. I believe it was filed at like 5:58 this morning.
Because it was filed at 5:58 this morning, I really haven't had the opportunity to look through it, so
Okay.
I don't really have the ability to comment on it, other than generally what happens is we can do proposed findings of fact conclusions of law either prior to an evidentiary hearing, we can submit them after as part of our closing brief.
Of course. And so I just want to know for the record, of course, you would still have the time, Mr. Page, to submit that from your side, and we'll talk about scheduling later. As far as the schedule for today, I know we're starting a little late, but you do have a full day here today. It's a Friday for staff purposes. I know we have at least one staff member who leaves at 4:30, so we would like to conclude at 4:30. We can go to 5 if it's needed, of course. So I just bring that up to mention, we usually take a couple of 15-minute breaks, one in the morning, one in the afternoon, more if needed. Of course, if you need to go to the restroom or something, let us know. It makes for a long day. But for our lunch break, councils, did you have a preference for 60 minutes or 90 minutes?
60
I'm not a
minutes
big
are on.
lunch guy.
Okay, so we'll do a 60-minute break. We usually stop around 12 noon or 12:30. So just let us know when you get to a good stopping point. I do have some stipulations here as far as exhibits, so thank you, councils, for taking the time to do that. That saves so much time. Are there any other pretrial matters before we get started?
Yes, Your Honor.
Okay,
Two things. One, we did object to all of the untimely witnesses, and during the calendar call, there was a representation made that the only witness that would have been potentially brought forward by the defendant out of those untimely disclosed witnesses would have been Mr. mother. However, my understanding is that not only is Mr. outside, but there are other additional witnesses that were also untimely in their disclosure, and we would certainly object to all of them testifying, not only because of their untimeliness, but as I described in my written objection to the court, that they do not have the requisite personal knowledge to give relevant and pertinent testimony concerning the contempt matters before the court today. We also would object to the woefully untimely disclosed exhibits from the defendant at approximately 5:09 p.m. last night. As the court observed from the pretrial memorandum that was filed last week, there were no disclosed exhibits from the defendant, and when I get hundreds of pages of potential exhibits, the night before we're set to start our evidentiary hearing, it is not only untimely, but it has become prejudicial because I cannot review those hundreds of pages and be ready to go the following morning, having been able to distill and incorporate all of those materials for the purposes of putting on an effective presentation today. So as such, Your Honor, we respectfully request the court prohibit any further witnesses beyond the parties to testify, as well as prohibit the admission of any exhibits from the defendant that had been untimely disclosed as of last night.
okay. Response, Mr. Page?
I am taking that as an oral motion. Normally what we do is we have a witness on the stand and we move for admission of an exhibit, and then we would go forward that way. And I understand that he's trying to circumvent that to try and avoid the matter being heard on its merits. It is what it is. As to the witnesses, because that was the first in order, the witnesses were disclosed 1 week after the deadline. I was retained at the last minute, and that was the reason for the delay. The question is whether there's any undue prejudice, and I don't believe there's any undue prejudice. It's his mother and a couple of other people. Whether you want to give their testimony whatever weight you want to give them, you can. Some may testify, others may not. It depends. But it would allow the matter to be heard on its merits, and that's really what the Nevada Supreme Court wants us to do under cases like Leslie versus Leslie, Dr. Khan versus Holm, those sorts of cases. So there is no undue prejudice, and that's really the question there, rather than trying to make a hyper-technical argument as to whether the witnesses should be allowed to testify. you can make that call as the matters proceed and make your call at that time. Again, this is way premature for that sort of objection to make. As to the exhibits that we're providing are simply summaries for the most part. There's an anger management class that my client has taken, and that's coming in. But summaries are summaries, and some of these summaries are compilations of our talking parents messages. Others are statistical breakdowns that my client has done to break down the various allegations of behavior order violation messages that he sent, and that covers a 1 year period for one sort of has all of the weeks laid out with what weeks there were behavior order messages that were quite frankly inappropriate, and others where it's sort of a heat map where you kind of group it together and see how many occurred during a specific week. Another is a calendar that has a statistical breakdown or a graphical breakdown, because sometimes the picture's like 1,000 words, as to when these objectionable messages actually occurred. So that's what they're objecting to, is actually a summary that's based upon the documents that we've already stipulated should come in. Again, we're trying to have the matter be heard on its merits. If we take a look at the NRCP 16.2 supplements that they provided, there's 18,000 pages of documents that we have to try and condense and collate and summarize. That's what my client has attempted to do. He's the one that's created these summaries, so he's able to lay a foundation as to what he did, what he looked at, and what are the conclusions that he reached based upon that. So there's really nothing objectionable there. Furthermore, yesterday afternoon, I received approximately 50 additional exhibits from opposing counsel. It went from about 83 to 134. All of those exhibits were various sorts of talking parents messages. I spent last night and still this morning reviewing all those and trying to figure out what's there when I have such a limited period of time in which to do so. Now, they can argue that those talking parents messages are summaries of what occurred in those 18,000 pages of documents that we have. It's really no different, just in a different form than what my client has done. So when they have, there's "you're a bad mother" sort of exhibits that they have, or let me think of one.
So is it like a compilation of each?
It's a compilation, and essentially that's what my client does in his Excel spreadsheet of those various exhibits. But remember, I did not receive those until yesterday afternoon. There are hundreds upon hundreds of pages that I've had to try and review while still doing trial prep work with my client to try and be prepared for trial here today. That in itself is truly prejudicial to me and prohibits me from being able to hear the matter on its merits. If they wanted to provide these documents for trial, then they probably should have provided those when the discovery cutoff actually was, rather than here the day before trial and trying to sandbag me. As an additional thing, it's just sort of maybe lack of respect or whatever. They provided exhibit books for the clerk, for you, for the witness, for themselves. They didn't provide exhibit books for me.
Really? Well, for that point, if I can comment, the ruling was Madam Clerk needs hers because she has to mark them. But I thought all others were going to be electronic, and we're sharing, right?
No, he brought a bunch of boxes for, he brought books for himself, he brought books for the witnesses, but didn't bring a book for me.
Where are my books?
I mean, really?
Well, I know that we did not want a situation where we had books just all over the courtroom, so it was my understanding that Madam Clerk would have her books. If it's easier, maybe I would glance at her books, but everything would be electronic.
I'll make it through, but it's just the point of, let's see how difficult we can make it for opposing counsel, for the opposing party, to be able to be here today and fight their way through all of this. And I've got everything up on my computer screen, and I'm ready to go that way. It's just a matter of courtesy or lack thereof that we're dealing with here. But we're looking here at the, the summaries that we have. They're really not very many pages. One goes from 62 to 68, so that one's 6 pages.
Let me just rule, Mr. Page, for the sake of time. I don't want to eat up so much of your trial time. In some aspects, you're correct. When we have a large volume of exhibits, it's not uncommon for counsels to create these summary compilations and divide them in different ways. However, the issue becomes whether the actual supporting documentation has been admitted. With talking parents, if it's just a reference to exhibits that we have that are coming in, they're stipulated exhibits, then I really don't have much of an issue with that. If there's just demonstrative things, we can deal with it on a case-by-case scenario. If it's something, of course, that your client would like to refer to because just of the sheer volume of exhibits and the allegations that we have here, which into the hundreds, we'll deal with that as well, because of course we would need to know what he's referring to, what he's referencing, what exhibits are supporting these summaries.
Yeah.
However, if it's just a pure new piece of evidence, that's different. So I know you're asking for us to object in real time, which it may not even be an issue. We know there's a lot of exhibits that may not even come in. So let me just say this, we do have a trial management order here, and both sides should adhere to that. Mr. Jimmerson, of course, the representation is that you gave him some things late last night as well.
It's not true, Your Honor. From the very moment that we filed the pretrial memo, it included the Dropbox with all 133 exhibits that we had at the time. There is now 134 because they include talking parents from June 19th, 2 days ago. They were disclosed 4 hours after those communications took place, and I attached a copy of the exhibit. I believe it's a 2-page exhibit as Exhibit 134 to that amended pretrial memorandum, or amended list of witnesses and exhibits. I also handed Mr. Page, right after our calendar call, a thumb drive with all of the then 133 exhibits at the time. We then had our subsequent meeting after the fact, and there was no claim of I didn't get all the exhibits. They've had Monday, Tuesday, Wednesday, Thursday, we're now Friday, and the first time I'm hearing, that they didn't get the last 50 exhibits was today. We heard that they were having problems accessing a Dropbox yesterday afternoon. I immediately remedied that situation, sent an email to Mr. Page, and did not receive any email back saying that they still had problems. If they're saying that they didn't receive anything until then because of Dropbox issue, they still had the thumb drive. The thumb drive had all the exhibits as well. However, notwithstanding all that, Your Honor, I should have known that this was going to be a problem before Friday morning, given the fact that we had been more than fulsome in our disclosures. And the fact that we had several supplements during this discovery process. We disclosed as 18,000 documents. By contrast, request for production number 12 requested all of their exhibits that they intend to or contemplate introducing at the time of the evidentiary hearing. We get Bates Defendant 1 through 2234, none of which are included in defendants A through G exhibits that were disclosed last night. Now, the talking parents messages, I believe in Exhibit B, so what I would call the naked talking parents messages, were part of the stipulations. But any summaries, any other documents beyond that, a heat map, that would have been appropriately disclosed in response to our request for production of documents. And the court will also see as one of our exhibits the request that I made to Mr. in April, asking him to supplement his discovery responses to make sure we had everything, and I got no response to that. So the idea that we were untimely is completely false. And given the history of this case and the procedural posture we are now sitting in, it would be wholly improper to allow them to use untimely disclosed documents that constitute new material. Exhibit B, perhaps, Your Honor, but everything else that's new shouldn't come in.
The documents don't constitute new material. They are summaries. And the rule is, once the underlying documents come in, which they have, the summaries come in as well. The summaries are meant to assist Your Honor and to assist opposing counsel, to assist everyone in determining what messages came in when, and what's the correlation between what they're asking for as relief and what the messages actually are, who, what, where, when, and why. That's what the summary provides.
So let's do this. Regarding the summaries, we'll deal with it in real time as long as there's a stipulation or no objection to the underlying message is fine. It is often helpful to the court. I'll compare it to like a marital balance sheet when we're dealing with numbers.
Yeah.
When we have the supporting docs, it's just a table, outline. I don't know what yours appears to be, but we'll deal with that. And if it's helpful, we'll entertain any real-time objections there. I'll note for the record, our trial management order was filed on February 16th, 2024. So going over to the witnesses, I'm always inclined to not allow late and untimely disclose witnesses to testify because parties often want to conduct depositions or something, so that they can have an opportunity, if they so choose, to talk to the witnesses about their testimony. What's being represented is that, and we know that these are primarily contempt allegations, that the witnesses would not offer any independent knowledge that your client couldn't offer about each of the allegations. And it sounds like many talking parents from the pretrial memorandums. So I don't know how they would be helpful, and if anything, maybe cumulative evidence. So I will say this, I will deny the request for the untimely witnesses at this time. We have a full day of trial. Let's see where we get as we get into the afternoon. Mr. Page, typically those witnesses aren't even necessary because here we need the parties' testimony. That's where these allegations lie, and that's the evidence that's most critical to the court. So I don't want to waste time and just say, oh, give it the weight that you think it desires. In this type of case, it's probably not much weight when the allegations is direct between the parties. So let's exclude them for now. I don't know whom else is out there waiting. Mom was named. I don't think that Mom would be an essential witness to this case. I don't know that yet. Let's get started with some evidence, and let's see if one of the allegations directly involves Mom, and then Mom's testimony may be important to the court. Typically though, in these types of hearings, it's not. So we'll exclude any untimely witnesses. With that said though, as far as scheduling, starting with plaintiff, how many witnesses do you intend to call?
We intend to call the parties.
Okay,
That's it, just
And-
two.
Mr. Page, notwithstanding that ruling, besides your client, how many other witnesses had you planned on calling?
Just my client and the opposing party.
Okay, great. Councils, are we going beyond the scope, or we're just going to recall in your case in chief?
We're happy to go beyond the scope simply for the purposes of moving things along.
Okay. All right then. Any other pretrial matters? If not, we'll get started with our first witness.
Your Honor, is the courtroom open to the public?
Yes?
Okay. Your Honor, then we have one of Ms. friends who's not a witness invited to participate.
The same with for my client, if you're not going to allow his witnesses to testify.
Any objections to any observers at all?
We have no objections as long as they're confirming that they're not going to be witnesses. Obviously, we would impose the
Of course.
exclusionary rule.
We'll impose exclusionary rules, so no witnesses can observe. Otherwise, open courtroom. John, we can let them in. And who will be our first witness?
We will be calling Mr. Stand, Your Honor.
Okay. Mr. Please make your way to the witness stand.
Your Honor, before I begin
Okay.
examining this, I would like to move into evidence to the extent it hasn't already been moved into all of the stipulated exhibits concerning the talking parents' messages. For the record, those would be exhibit numbers 32 through 44, 50, 55, 57, 58, 60, and 134 at this time.
Okay, those are all the stipulations I have. We will move those into evidence at this time. All of those will be admitted formally by the court, okay? Welcome everyone. Just for our record, I can just please note who we have here with us observing on plaintiff's side. Your name for the record, ma'am? And what's your relationship to the parties?
I have known for probably over 20 years.
So friend? Okay, thank you for being here. And on this side, who we have?
A friend.
Okay,
And Sasmada.
good morning, ma'am. Thank you. And sir?
Friend of.
Thank you. Welcome, everyone. Please just make sure not to react, do any gestures while the witnesses are on the stand, and then I know John will be watching out for that. Ms. If you would please stand, Madam Clerk will swear you in so that you're under oath.
Please raise your right hand. You do solemnly swear that the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth under pains and penalty of perjury.
I do.
You may be seated.
Your Honor, I may interchange between sitting down and standing up if the court is
That is fine.
given the electronic documents we have. Good morning, Mr.
Good morning.
My name is James Jimmerson. I'm an attorney for, I'm going to be asking you some questions today.
Yes, sir. We're familiar with each other. Good to see you.
So, you are the defendant in this matter. Is that
Yes,
right?
sir.
Okay. On February 6, 2020, the court entered a stipulated decree of custody concerning your rights and concerning the young child. Is that right?
The court entered a stipulated
Yes.
decree of custody? Yes, I believe they did.
And is your daughter with my client?
That is my daughter, yes.
What is her birthday?
2019.
So she's turning 5 a couple days from now, is that right?
That's right.
Okay. During the course of this matter, you had produced a number of documents in response to our request for production of documents, is that right?
That I produced? I believe Kurt Smith produced some of what I sent him.
Okay. But those documents were produced on your behalf, is that right?
I believe so, yes.
Okay. And those had the Bates labels prefix DEF 16.205.
I can't speak to what Kurt Smith did or did not do with this misorganization. That's why he's not my clerk. It's not why he's not my, but I can say that, but if that's the case,
I'm just asking what the Bates prefix was.
I don't know what Kurt Smith submitted to you, sir. He's not my attorney for a reason.
Didn't you review some of those documents that that Mr. Smith produced on your behalf during the deposition earlier in
I was
January
too
of this
busy
year?
being yelled at by Mr. Smith about him telling him to perjure myself and deny the fact that he did not produce things.
Are you waiving your attorney-client privilege with Mr. Smith?
Absolutely, I don't like the man.
Do you remember reviewing those documents, or at least some of those documents during your deposition on January 31, 2024?
I'm sorry?
Do you remember reviewing some of the documents that were produced on your behalf during your deposition that took place on January 31, 2024?
I was just thinking about the Kurt Smith stuff. It got me a bit upset. Can you say that one more time?
Do you remember reviewing some of the documents that were produced on your behalf during your deposition that took place on January 31, 2024?
Do I remember some of the statements that I made?
No, reviewing the documents that were
Reviewing.
produced on your behalf during your deposition that took place on January 31, 2024.
Reviewing the documents that were produced? I remember some of them, yes.
Because you had produced approximately 2,200 pages of materials prior to that deposition. Is that fair?
I think you keep saying I produced. Kurt Smith produced.
You produced through counsel approximately 2,200 pages of
On my
documents.
behalf, counsel produced something, yes.
And that would be approximately 2,200 pages of documents,
I
correct?
did not count what he produced. I just know he yelled at me as per your indication during the deposition that he actually had produced stuff and I needed to deny everything. So it made me confused. That's what Kurt Smith told me, sir.
Okay.
So
Do you remember reviewing text messages that you had produced? Text messages between you and my client?
reviewing? No, I remember forensically extracting text messages and sending them to Kurt Smith.
You don't remember the extensive questioning that I subjected you to concerning those text
I
messages
do
during the
remember a
deposition?
very long deposition, yes.
Okay, so you do remember reviewing those text messages that you produced, or you, through your counsel, produced
I
during the
don't
deposition,
remember.
right?
I do remember the deposition, yes. And I do remember the text messages were brought up during the deposition, yes.
Okay, and you remember reviewing those text messages, right?
Yes.
Okay.
Well, reviewing them with you, all of them? No, I remember you asked me questions, sir. Yes, and I remember answering them.
Okay. Mr. Pastor, can you please put on for the screen for the witness Exhibit 68. The Bates labels for these are 16.205, 001215 through 1975.
Could you repeat that?
Exhibit 68, please, Mr. Pastor.
Didn't say 68.
counsel, just for my knowledge, because I didn't have a specific stipulation to 68, is there any objection?
That's what you're looking at.
Is there an objection?
Let me take a look at it here one moment.
Text
please.
messages, apparently. Of course, I don't review any of the exhibits beforehand, so I don't know. These are also talking parents, or,
It's a hugely big exhibit. It is.
well, Mr. Jimmerson, are these
It's
also talking
760
parents?
Part one is 761 pages, and part two is. Yeah, it's 700 and some pages, close to 800. I would just ask that my client take a look at that in his exhibit book and make sure that looks appropriate. I'm not gonna be a stickler about it, but just glance through it and make sure.
They are on the screen, Your Honor, because they were so voluminous.
I believe this is before, we had any, I was served with any valid decree, but that's all I can say so far.
So this is what I'll do, Mr. Page, and for Mr. Jimmerson as well. Because they're being published, I just won't look at the screens until we have a ruling or the exhibits are admitted, but you can go ahead, sir.
Are those that are on the,
Everything, I mean, these are from 2020. I was not served by any valid decree, and I don't think there's a valid decree.
Your Honor, can we-
28.
I would move to strike the statements by the witness. There was no question pending.
It'll be stricken.
Thank you.
And sir, just for note the procedures, wait until council asks a question, and then you can answer it, not just talk out of order.
May I just clarify then, what they wanted me to look at, confirm?
Yes, you can ask, I believe that what they're specifically asking you to look at is on this screen that I'm trying not to view right
What-
now.
What,
But can you see the text messages on the screen, sir?
No, so there's numbers here, they're
Okay.
very well numbered.
So you prefer to use the book,
Yeah, like they
Mr.
have,
Jimmerson, what's the
Yeah.
date number?
It is defendant 16.205, 1215 through 1975.
so,
And what page is that? Could you-
That is, Mr. Patrick, can you please scroll down? That is 1215, and then you have approximately 760 pages.
So if you can't see that, sir, if you can go to 12:15.
I don't believe that we have the text messages in full format except in those binders behind. So if Mr. Permitted to do so, can he get near the screen just to be able to read what he
Is
needs?
there any way to enlarge that?
Mr. Patrick, can you enlarge the screen,
Zoom
please?
button? Yeah, let's do it that way.
these are not,
Can you see the screen now?
yes, I can. But I can't do the dates.
Well, we're to begin with that. Can you blow it up a little bit more, Mr. Patrick? Can you scroll to the top page, Mr. Patrick? Can you see that this first text message is February 27, 2020 at 20:50 p.m.?
Mm-hmm.
Okay, can we just confirm the date stamp on this first page, Mr. Patrick? You see that that is base labeled defense 16.205 001215?
I see that's
Okay.
written, yes.
And so you now recall that the prefix for the documents that you produced in this case, at least the base level prefix was defendant 16.205 followed by the numbers, is that
I don't
right?
recall ever writing anything like that. I did not produce that, my former so-called attorney did. But yes, I see that, and I confirm that if that's what you say you received, that's what was produced.
And that was part of the range of documents that you reviewed during your deposition, correct?
That was a part of the range, I believe so, yes.
Okay,
It
and
looks like,
can you scroll down, Mr. Pastor, the very bottom page? The base label at the very bottom page? Can you download it? Can you download the hard copy on your computer so that we're not running off the internet, if possible?
To me, the things, one, you just maybe turn to the last page of that book.
I don't believe that we have the front and last in those exhibits. What's before are just snippets.
If you tell me the date, I can get it.
Can I just show
I can get it
them?
right
That's
here.
fine. He's got it right here. Okay, sorry. Thank you, Mr. Patrick. Do we see here that the bottom of the final page of this document is base labeled DEF 16.205, 1975?
You had to blow it up again. Okay, let's see, the numbers, sorry.
Can you zoom in, Mr. Patrick, please?
DEF 6.205-001975, I believe that's what I'm seeing.
And these are the text messages between you and Mr.
Text messages, it says labeled 1/1/2020, or extracted 2024, I believe. I don't know what date these messages are.
I'm asking who the.
Are they text messages? Yes, I think dating back to 2016.
So the text messages that we are seeing are between you and Mr.
Again, yes, but I don't know which date.
They're in various dates, right?
Going back to 2016, yes.
Well, but we saw the first page was only from February 27, 2020. We see his last date being in October 16 of 2023. Is that right?
I don't think we should comment on what we saw. I'm still trying to figure out what I'm looking at. But this label says 10/something/2023. That's what I'm looking at.
Correct. So we have a range, a date range of text messages between you and exhibit between February 27, 2020 to October 16, 2023. Is that right?
Yes,
And your text messages, so your communications are on the right
that's correct.
and Mr. communications are on the left. Is that right?
I don't know if you have communications there.
Can you scroll up to see?
Yeah,
So we see Mr. communications in this document are on the left. Is that right?
that seems to be the case, yes.
Okay. Your Honor, I'd like to move this into evidence as Exhibit 68.
Any objection, counsel? Text
There's no
messages.
objection as to the authenticities that are produced by my client's prior counsel. I would object to the relevance of a portion of those because we're looking at records going back a little over 4 years. Records that are more than 4 years old would be not really terribly relevant to the court determination here today, I don't believe. I think records that would be, say, within a 12-month period of time, those would be relevant. Anything prior to that probably would not be.
Any response, counsel?
Yes, Your Honor. Given that this is the first and only contempt proceeding that we've had in this matter that stems from the entry of the stipulated decree of custody, that all of the communications that would be at issue would begin with that date in February of 2020 to the present date. And so while it is voluminous, the court, as certainly as reviewed in our pretrial memorandum in the pleadings and papers to date, I can appreciate the alleged acts of contemptuous conduct are also voluminous. And therefore, given the nature of what's alleged, the time period of what's been alleged, and the idea that something that happened 4 years ago wouldn't be relevant, that's for the court to decide. That it's a weight, not an admissibility issue, given that these are the communications between the parties that would give rise to the acts of contempt or the alleged acts of contempt that we're submitting to the court.
And Your Honor, as things go to relevance, if we look at things like DUI convictions, DV convictions, other types of convictions in the criminal realm with which you're extremely familiar, the older those things get, the longer, the less weight those things are given, and the less weight they're given, the less relevant they become. You can also look at equitable arguments such as latches. If this was the terrible thing that she actually believes that it is, then she would have brought something up in 2021, 2022, sometime before 2023, which doesn't really make it terribly relevant for this court's determination because it doesn't make it very relevant for this court's determination. It shouldn't be given any weight. If it shouldn't be given any weight, it's not relevant. It should be excluded.
Thank you, counsel, which would all be great arguments from your end on behalf of your client, but certainly text messages between the parties can come in. My question was pertaining to defendant his representations that some of these messages date even further back to like 2016.
Those have not been included in the
Okay,
exhibit, Your Honor.
perfect. So 68 then will be admitted, and I note the volume, so Mr. Page, as the actual exhibits and the page numbers are presented, of course, if you have a further objection, by all means, please make it,
Yes, sir.
okay?
In your honor, given that we now have the admission of all of the text messages between the parties that have been submitted as part of this exhibit, as well as the admission of all the talking parents communications, we respectfully request the court admit into evidence the exhibits 86 through 133, because they are the combination of both text messages and talking parents messages.
I will agree that there are summaries, there are snippets of various things for which they're alleging contempt, because they are a subset of the talking parents messages, which are privileged stipulated to come in. I would have no objection.
Okay,
Thank you, your honor.
so all of those are admitted, and for the record again, counsel, from what number to what number?
It would be, your honor, 86.
And while I'm stipulating that, Your Honor, I don't waive my objection for things that are in there, which there are, that go back to 2020, 2021, 2022, and so forth, as to their relevancy and importantly, what weight they should be given. So I'm not waiving that portion of my objection, just with the fact that they're actual talking parents messages.
Understood, counsel, thank you.
It would be 86 through 133, I believe 134 was already admitted, as well as exhibit 68A, which is also a subset of the text messages, but does not include talking parents messages.
And also, because they're part of the talking parents messages, there are things that also, that my client's summaries rely upon, so that's important as well.
Okay, noted, 66A. Okay, do you have all those?
86 through 133, 66 days.
Yes, ma'am. All right, we're moving forward, all of those are admitted.
Thank you very much, Your Honor. Mr. You also have produced a number of videos, amongst other documents, in this case, responsive to our request for production of documents. Is that right?
I submitted a number of videos to Kurt Smith. I'm not positive what he submitted to you other than what you went over in the deposition.
Isn't it true that the initial disclosures only disclosed 2 videos?
If that's the case, that is pretty a sad affair, but yeah, if that's the case, sure.
You remember only reviewing 2 videos that had been labeled as exhibits by your prior counsel in advance of that deposition,
No, I
correct?
do not. I remember submitting over 55 to 70 videos in a Dropbox that's shared with Kurt Smith to this day, in response to your in response to your request. Again, what my incompetent counsel did not send to you, that's still a surprise to me, and I'm still figuring some of that out.
Your Honor,
For example.
Hold on, sir, there's some question pending for you guys.
we would make reference to Exhibit 73. It's not been admitted. Mr. It is in one of the books. It's a shorter exhibit. Can you open to tab 73? This is for the court's reference. Defendant's initial disclosures of witnesses and documents pursuant to NRCP 16.205. It's part 1. It does not contain the documents. It's just the front cover pages.
What number is that again?
73?
It starts at 86. Oh, I think this,
No, it would be
Do you have
in
another
there.
there's one book missing. It starts at 86, goes up to 125, sir.
It's just 86?
Yeah.
Okay.
I can't.
Mr. Pastor, can we get Exhibit 73 on the screen, please? I appreciate it. Mr. This is, has been remarked as defense initial disclosures of witnesses and documents pursuant to NRCP 16.205, Part 1. See that, sir? Can you zoom in, Mr. Pastor, please?
I see that, yes.
Mr. Pastor, can you please scroll down till we see Exhibits Z, I believe, in the disclosure? Just refresh your recollection that there were 2 videos produced.
I see that that's what Mr. Smith submitted. I also see that it was submitted Department J, was it, or Department Q, at the top, even though I think you got the department wrong. I'd like to just note that for the record. That's how.
Mr. We're trying to move things along here, and I appreciate the additional context, but for the purpose of my question, please just answer yes or no if possible.
Yes, I see the person who couldn't get the right department on the sheet also only sent you 2 videos. Yes, sir.
Do you believe it is appropriate to be repeatedly making such statements about your former counsel?
I think
Objection
I would-
argumentative. It's not, we're not establishing a fact relevant.
No. It is certainly relevant, Your Honor, because it goes to the continuing conduct of Mr. His communications, which are the central part of this dispute, are inappropriate concerning someone who isn't a party to this case. It informs the court as to whether or not he's going to be able to be trusted to engage in appropriate communications going forward. So having an answer to this question is important because it goes to a state of mind, Your Honor, as to the appropriateness of the responses or his discussion of his prior counsel.
I mean, I don't want to really go here, but he does have the right to speak his opinion. That's part of the First Amendment that we have, and to say that he doesn't have a right to have a thought that can be expressed, I don't think it's an objection that can be granted.
I understand your point, Mr. Page. The idea here, though, is that we don't want to distract from the central issue, which is the contempt regarding the parties. And, I mean, Mr. Jimmerson, I really thought that's why you were letting it go, because of what it could demonstrate. But let's just handle it this way, sir. I have noted your displeasure with former counsel. You may have some actions there, but today we're not dealing with any conflicts or attorney-client issues that you've had with former counsel. You have Mr. Page. He's here to do his job on your behalf, so it's noted. Stop the comments about Mr. Smith. You were not pleased with his services. I got it. For the sake of time and also so that we're not distracted and stay on issue, please just answer the questions as asked by counsel, okay? Thank you.
So this refreshes your recollection that 2 videos were produced in your initial disclosures by your prior counsel, or by and through your prior counsel. Is that right?
I would say refreshes. It's the first time I'm looking at it, and it does seem to show that 2 videos only were produced out of the multiple that I submitted.
What do you mean it's the first time you're looking at it?
It's the first time I'm looking at it.
What do you mean by it, sir?
This document in front of me.
Isn't it true you were shown a copy of your initial disclosures during your deposition, sir?
But I was shown copies of thousands of text messages and other things that I was questioned about. I don't recall looking at this. But perhaps I have looked at this. I don't recall looking at this, and I don't recall seeing that only 2 videos were produced.
So the more accurate testimony now is that you don't recall whether or not you saw it, not that you haven't seen it. Is that right?
That would be more accurate, correct. This is the first time I'm cognizant of seeing that only 2 videos were produced by Mr. Smith. But again, I don't want to mention his name, I'm sorry. But
Your testimony is that this is now in court, as we stand here today, or as you sit there today, the first time that you are becoming aware that only 2 videos were produced by Mr. Smith?
there was a moment in the deposition where Mr. Smith put, I don't want to talk about it. May I answer?
I mean, it's fair. He
Yes.
specifically asked about Mr. Smith, but go ahead.
I was pulled aside, and during the deposition, he stopped it, and he came back, and you asked him, what did your counsel ask you? And he said, objection, I'm not going to tell you what. Let him answer, and you pointed out to Mr. Smith how the law actually works. I have to tell you. And he told me, and I said, he told me, just to stop giving excess information. Also, what had come to light outside was, in compliance with your request during the deposition, sir, was that he told me, oh, I didn't produce all of these documents, so I need you to just say that you don't recall as much as you can, because otherwise I'll have to produce more documents, which was very confusing to me, because I had spent the past 5 days producing everything possible that I had sent to both Trevor Creel, previous counsel before that, and to Mr. Smith. So that's what happened, and I do believe you recall, sir, you asked Mr. Smith what was spoken about when the deposition was stopped, and you produced some sort of deposition rule called Coyote something, that states that you have to say what your counsel told you. What my counsel told me was to go perjure myself because he didn't produce any. He can't produce myself anything, essentially. That was kind of the beginning of the end of my time with him. Again, I don't want to disparage the man, I just want to answer the question.
So, Mr. I believe Mr. Jimmerson's call, the question though is still specifically about these 2 videos. And it's today you're learning that only 2 videos were produced, is your testimony?
Yes.
Because clearly I was not present at the deposition, not privy to what happened there.
I've been sending the Smith Legal Group videos since I took them on as counsel to replace Trevor Creel.
Okay.
So.
So just pause.
Do you remember having a meet and confer with me after you no longer were using the services of the Smith Legal Group?
I do.
Do you remember that the subject of that meet and confer were your discovery responses?
My call is about a med match test.
Isn't it true that you provided additional videos in response or after a meet and confer you and I had sometime in February of 2024?
Additional videos?
Yes.
Based on what you requested from the conference?
Yes.
I'm not sure. I require sending you a med match test, and whatever you asked for. I remember mostly the med match test because it was, I asked you during the conference, do you need this med match test in reference to the negotiations for settlement as per EDCR 5501, which you represented in court later. And you said yes, something along those lines. I was like, okay, in that case, sure. I believe I even filed a memorandum.
So now you're losing me, okay? We need very clear, direct answers, particularly because everything's being recorded, and I likely may need to play back the testimony so I can understand. So is that a no, then, that you do not recall submitting additional videos?
I recall submitting a mid-match test after being told that it was necessary for settlement.
I'm asking about videos. Isn't it true you produced additional videos after you had discharged?
I don't recall sending videos. If I did, perhaps, and you asked me to. I remember someone came to my house for a thumb drive.
And you would put videos on that thumb drive, isn't that right?
I don't recall anymore what I put on that thumb drive.
When did that happen, sir?
It was sometime in February.
Mm-hmm.
There's a lot going on.
Let's look at, do you remember during the deposition, you played videos that had not yet been produced?
You asked me to play stuff on my phone. My counselor didn't.
Isn't that right? Isn't it right that you played videos that hadn't been produced in the action during your deposition?
Yes.
Okay? Isn't it true? Mr. Pastor, can you please open Exhibit 46? This is a recording video. Mr. had labeled number 2 that he had indicated and disclosed was taken from January 30, 2024.
Is it 42, correct?
46. Mr. Do you recall this video?
I do.
Isn't it
I
true?
think-
Yeah, if we want to
I'm
stop.
not sure which video it is because I always have a video every time I pick up my daughter, so I have to see it.
So you would have, this is normal style of how you begin some of your videos. Is that right?
I would say there's no normal style to anything.
Wasn't you just said that that could be many videos because you have some of these
My
angles
phone
sometimes?
down, sometimes and I hit record before I get to the gate to show that I'm having difficulty at the gate.
That's the inside of the car, right? Of your car?
Yes,
That's you driving, right?
that's correct.
Okay. Have you edited any of the videos that were produced by you during this action?
During this action,
During this case?
any of the videos? I don't believe so.
Okay. Do the events that are depicted in the videos that you produced in this case fairly and accurately depict what was going on at the time?
What was going on at the time of the day?
Mhm.
Yeah, they have timestamps, sir. Yes, sir.
So the answer to my question is yes, they do.
Yes.
Okay, Your Honor, I'd like to move into evidence exhibit 46.
Counsel?
My response to the relevance, I'm not, it's a video of what relevance has to the contempt proceedings is extremely unclear.
Response, counsel? Relevance?
Your Honor, I'm happy to lay some additional foundation to find out if he has any recollection of what happened.
Okay.
Do you have any recollection of what happened during the pickup of on January 30, 2024?
January 30th, 2024, exactly. I believe this is the video where you noticed that I was angry and I was talking to myself, perhaps? Is this it? Because I think there's two videos you went over. Is this the one? Because there's only two videos you went over. So is this the one where I was just...
What do you mean there was only two videos that I went over?
You just said there's two videos you produced. Two videos you went over, I think. So I don't know.
You don't remember what happened on January 30, 2024 when you picked up?
Remember exactly January to the 30th. I remember you asked me about a video and asked if I had voices in my head and I was talking to them.
Isn't it true that on January 30, 2024, you engaged in repeated violations of the behavior order from the behavior order terms from the decree?
In January 30th,
Yes.
2024?
Mhm.
Repeated violations?
Yes, multiple violations.
Not that I recall. No.
Do you recall calling my client names, or at least one name, on January 30, 2024?
In messages or in
No.
person?
On videotape.
On January 30th. Right, this is the, okay, I know, so this is the one when had me recording and said, "You're on my property." Yeah, I recall this one. Yeah.
Can you answer my question?
I do recall this one now.
So,
Yes.
so you do recall that you had
Yes.
called my client a name on this?
I don't think I called her a name.
Okay.
I don't recall though, but.
Your Honor, we would now like to move this into evidence as Exhibit 46.
Any further objection, Mr. Page? Sounds definitely relevant and
The
now.
relevance contained there is that, the allegations that, my client called the opposing party a name.
I mean, that's one that I've heard thus far.
Okay, if that's what the allegation is, that would be relevant to the proceedings here today. I haven't heard what it is, so I don't know.
There's a
I mean,
second,
Also, the testimony, of course, is that either he doesn't recall or did not do, so it could also be impeachment, definitely relevant. I mean, we're here for numerous allegations of this alleged conduct, so we'll play Exhibit 46.
It's kind of long, so maybe we can then get a time index.
How long is the video?
the video, I believe, is approximately 15 minutes here. I'm just going to show a clip of it,
Okay.
of each one, but I'm trying to lay the foundation of the court so we can get this moving along. So,
46 is a minute, and we'll
Thank you.
play a clip.
okay.
Counsel.
Mr. Patrick, because 47 is the companion video taken by Mr. It's effectively kind of the second part of the event.
Are we going to get a time index for 46?
We're going to start at I believe we're going to start at 2:20 for 46. For 47, can we bring that up? Mr. Do you remember that during your pickup of January 30, 2024, you took a second video?
I believe so, yes.
And that also documented your words both to my client as well as to, is that right?
I believe so. As to, I haven't reviewed the video, but I believe the video did show myself trying to sue after this conflict.
Do you remember telling her? Telling, I'm sorry that she, in reference to my client, started that argument.
I don't recall recall that, but if I did, that's unfortunate and clearly a violation and not something I should be doing and haven't done since. I don't believe will in that manner.
What do you mean in that manner? Haven't done since in that manner? I mean, using those exact words?
I'm trying to make sense of what you're asking me to recall without playing a video.
No, I'm talking about the words that you just admitted to saying that that's a violation of the behavior order and that you don't believe you've done that ever again since in that manner. I just want to understand what you meant by you don't believe you've violated the behavior order since in that manner.
Again, can you please repeat your question?
What did you mean when you said, I don't believe I violated the behavior order since in
I'm
that
literally
manner?
losing track of your original question of what you claim I said without playing the video at this point.
I'm asking you what you meant when you used those words, sir.
I don't recall anymore. I think we've gone back and forth 7 times. Can you please go back to the original question?
You don't recall your
Yeah.
line of, please let me finish my question before you begin. You don't recall your line of thought from approximately 1 or 2 minutes ago?
Literally, like, I'm trying to recall, because 1 or 2 minutes ago, you're asking me, do I recall this answer to this question of yours? You're coming at me so aggressively right now. I'm trying to be clear with you. Let's just repeat the question.
No. We're moving on.
Yes, sir.
Because you volunteered the information that you didn't believe that you violated the behavior order since January 30, 2024 in that manner. I want to know what you meant when you volunteered that information.
And I was speaking off the cuff, and I was trying to make sense of what you were implying.
Was that accurate testimony then, sir?
I don't believe so.
You don't believe it's accurate testimony then?
I believe I don't know what we're talking about anymore right now. What, can you please get clear references about what you're asking about, what was said? and
You
what
stated,
speak-
I don't believe I have violated the behavior order since in that manner, right?
Since what exactly, I don't recall.
January 30, 2024, the events depicted in the videotape.
What, the videotape I have not seen, that we have replayed.
So sir, like, if I can, counsel, just for clarification, what I heard from your testimony just a few minutes ago was that counsel asked you if you made a statement, something like, sorry, your mother started that argument. You testified that, believe so. If so, it was unfortunate and clearly a violation. Do not believe that I violated in that way since.
Yeah.
So I believe counsel's next question was, is your testimony that you have not violated in that manner, or if you can clarify what you meant by have not violated since?
Thank you, Your Honor, I really appreciate that. That's definitely, if that's what was said by me, regardless of any justification, that is not okay. Should not be speaking that way in front of her mother. I've been taking great care not to do so or violate the behavior order at all, despite any antagonism for months. I believe this might have been the first behavior order violation in many months. And I do believe I've been making a concerted effort to not make any violations since.
So that's what you meant by you haven't violated, you believe you haven't violated, you've made a concerted effort. Is that a fair summary of your testimony?
Yes, sir.
Okay. Isn't it true that you said, Mommy's not hurt, trust me, she wanted this. That's why she took you out of school early.
I believe I did say that, yes.
Okay, so you do recall the events of January 30, 2024
Roughly,
before we
think.
reviewed the video.
I don't know if that's an exact statement that I said, but so I can't say. I would need you to play the exhibit.
But you don't have the
Photograph.
recollection. I'm not asking about an exact quote. Am I getting the thrust of your statement correct?
So you just gave me an exact quote. Why don't you just play the exhibit? I mean, I can't ask you questions, but you gave me an
I
exact
would agree
quote.
with my client that if we're gonna get an accurate record, you probably should
We're-
play the video
we're-
so we can compare with what was said on the video as opposed what his answer is going to be.
The legal objection, counsel. So here's the thing, I'm not going to control Mr. Jimmerson's strategy here, and certainly, sir, you cannot ask questions of counsel, as you just noted, or ask him to do things a different way. council has the right to ask questions, try to lay a little more foundation. I have no idea what's going on at this point before this video is played. It doesn't really seem like you do either. I get that. Where I think we are is 46 is a minute and 47 apparently is related. A second video taken by you, sir. So it was like just trying to lay some foundation about that. I'm fine just admitting both and playing both.
Yeah, that's fine. I just want to move right into 47-year-old. I'm just trying to get the materials in first because then I want to get into the meat of these
Understood.
materials. He's claiming he doesn't remember. I obviously got to jog his memory a bit before we try to get them into evidence, Your Honor. So are they both admitted?
Yes.
Excellent. Thank you, Judge. All right. Your Honor, Mr. Do you remember during your deposition that you had been asked questions about the different companies or business entities that you were a part of?
I believe so.
Okay, and isn't it true that you disclosed and or confirmed that you had been a member or a manager in certain businesses in Louisiana, is that right?
Objection, relevance, this is about contempt.
Response?
Yes, Your Honor, one of the requests that we're gonna ask the court to purge the contempt is going to have Mr. pay for a communication coordinator. So establishing some basis for a bit of financial wherewithal is all I'm trying to establish.
I think that would be the end, not the beginning.
Again, so essentially, I understand this witness is called first. You agreed to go beyond the scope, and this is essentially cross-examination. So I will allow it in whatever order counsel would like. And then, of course, counsel, you have the right to cross-examine however you like. You can answer, sir.
I believe, so the question again was it parent,
Can you
was
please
it
repeat the
parenting
question?
coordinator?
Yes, Your Honor, I was just establishing the foundation for why. I was asking, do you recall that you had stated, disclosed, confirmed that you had a membership interest in certain entities or businesses in Louisiana?
Yes, sir.
Okay, can you tell us what those businesses are, sir?
Sasco LLC, 50%.
What's it called?
Sasco LLC, 50%.
Any other businesses, sir, that you are a member or a manager of?
Plus Station, 50%. I believe.
I didn't hear that.
Plus Station, 50%.
Plus Station, 50%. Is that Plus Station LLC, sir?
I believe so.
Are you a member or a manager of Southern Novelties Enterprises LLC, a Louisiana limited liability company?
I don't believe so.
Are you or have you ever been a member or a manager of Hospitality Plus LLC, a Louisiana limited liability company?
A long time ago, yes.
You're no longer a member?
That company was sold in 2017, and her father advised me on the sale of that company.
Okay. Your Honor, permission to move into evidence Exhibit 22, the certified copies of papers filed with Louisiana Secretary of State for Hospitality Plus LLC. They are self-authenticating documents as they have the Secretary of State's of Louisiana's seal.
Any objection to 22, counsel?
I didn't put the record. The holdings of that company were sold.
There's one other question, Andy. I would question object to the relevance because one of these documents is from 2009 and one's from 2012, 2013. Relevance and foundation as to whether these entities are still in existence or in operation.
Okay, any
Your Honor.
response, counsel?
Yes, Your Honor. What was requested and what was produced were the certified copies of the entire Secretary of State file that on file with Louisiana Secretary of State, and therefore all of the information, to the extent there would be, for example, any dissolution information, revocation information, would be included in those documents. And obviously, some financial information. I'm just trying to get the documents in, Your Honor. Okay, that's the whole purpose of this. And because the financial component has some relevance here, we're just trying to get it in for the court's consideration. That's all.
They also expound on the objection of relevance. There is no foundation as to whether, one, these businesses make any money, whether they're operating, whether they've been sold. There's many things that we don't know that would otherwise assist Your Honor in the ability to make a determination based upon these raw documents themselves. Would assist Your Honor to make a decision. It would be bank statements, check, tax returns, K-1s, that sort of thing, which obviously none of these documents are part of that exhibit.
Your Honor, in addition to establishing the assets, either current or former of Mr. obviously they go to credibility because they also serve as impeachment because Mr. had testified just now that he only had interest in certain businesses, and we just found out, he just disclosed, that he had an interest in Southern Novelties Enterprises LLC, and upon further questioning, he admitted that he had and does not have any longer a interest in Hospitality Plus LLC.
There is no business valuation to say whether these things are actually worth anything, whether they're, like I said, whether they're actually operating. There's nothing here that's going to assist Your Honor in providing evidence relevant to Mr. ability to pay anything of what they're demanding.
So this is what I'll do. I'll admit the documents. I agree that whether it's going to help assist me with defendant's financial ability to hire a parenting coordinator, I do not know what else is coming in at this time. Hopefully there will be some sort of financial information tied to this, bank records or something, so I'll admit this. But of course, you can reserve if that is not presented by the end of the evidentiary hearing, Mr. Page.
Right, and just so for potatoes, the Nevada Secretary of State website is littered with companies that do nothing.
Of course.
Your Honor, we would do that. We would request that the court would move to admit Exhibit 24, which are the certified copies of papers filed with Louisiana Secretary of State for Plus Station LLC.
Okay, and you just testified to 50% ownership there, so 24 is in as well.
We would also respectfully move into evidence Exhibit 26, the certified copies of papers filed with Louisiana Secretary of State for Sasco LLC.
Sasco 26. Do you have any objections, counsel?
What the documents are is articles of organization, articles of organization, so the record's clear, an initial report that's dated, let's see, 2008. There's some changes of registered agents, removal of members. There is a notice here that's dated April 15, 2021 that says that, dear sir or madam, in accordance with provision of the Louisiana statute whereby limited liability has failed to file an annual report for 3 consecutive years, the Secretary of State is directed by law to revoke the articles of organization, and that would be for Plus Station LLC. So, I mean, again, this admitting the documents themselves without laying a foundation as to whether this entity has its organization revoked doesn't assist the court in being able to make a determination, quite frankly, hinders it because that sort of information, which I think is important, is not part of the foundation that's being laid.
Just trying to get the documents in, Your Honor. We're going to get to the next step of the process. And 26 had to do with Sasco LLC and not Plus Station. Plus Station was in. Exhibit 26 was the one that was being subject to a potential objection.
I'll just note that based on defendant's testimony that he's 50% owner in both of those companies, I will admit both 24 and 26. Again, I do not know what weight this information will be given and how it will assist me at this point because I do not have any other information. I predict that may come later, and if not, you'll have a great argument, counsel, but they'll be admitted.
Thank you, Your Honor. And finally, Exhibit 28, which are the certified copies of the Louisiana Secretary of State papers for Southern Novelties Enterprises LLC.
Let me take a look at this here.
Okay.
so the record is clear, it looks like here that the articles of organization for Southern Novelties Enterprises LLC may have been organized in 2023. No other information is available as to whether it's actually doing anything other than being registered with the Secretary of State.
Noted. I'll omit 28 then, and with the same note, counsel, I don't know how helpful it will be, but the document will be omitted.
Thank you very much, Your Honor. We would also respectfully request that the court admit into evidence Exhibit 30, which is a certified copy of a cash sale document from Louisiana Secretary of State concerning Plus Station LLC.
And again, so the record is clear, Your Honor, for this particular exhibit. The cash sale is filed and reported in 2018, 6 years ago. And because this record of a cash sale is from 6 years ago, I would object on it coming in as has no relevance to anything that's occurring in 2024.
Okay, response, counsel.
Your Honor, it demonstrates that Plus Station has assets regardless of whether or not there have been the appropriate satisfaction of the filing of the annual list with the Louisiana Secretary of State, because Exhibit 31 is going to be another cash sale document from Plus Station LLC dated from 2023. So it tells the history of the assets of this business for which Mr. has an interest.
The fact that there is a cash sale in 2018 does not connect to the idea that we would have any assets in 2024 or have access to income in 2024. There is no rational connection between the position taken from when the sale occurred to what's happening today.
Okay, and what is your position on 31 from 2023?
For example, in 2020, as to the sale that occurred in 2023, the sale amount was for $110,000. The seller, the signature on the sale is not, so he didn't sell anything. Apparently one of his relatives, because the last name is somebody who sold it. So I don't know what the relevance is that somebody is selling something as to what what assets or income might be.
Even though his testimony is that he's 50% owner?
If he was a 50% owner, and again, I would have to check and see what the changes in ownership would have been over the years with the Louisiana Secretary of State. However, I can see here that the one signature that is obtained for a seller is if had any ownership interest in the entity when it was sold, his signature would have been required. I mean, that would go with, if he had a meaningful interest in the property, that would require his authorization in order to sell it, unless it would have been some sort of minor minority interest in the property for which his consent wasn't required.
Your
And
Honor?
assume some facts.
But
But
the document does all the work, Your Honor. If Mr. Page were to read to the bottom of the document, you would see Mr. signature on the document entitled Certificate of Authority to Sell.
that was going to be.
Counsel is correct, I'm kind of doing this on the fly. And I got to the page here where I saw this, and it says, okay, yeah, it does say that. So he is giving his authorization. What the distribution was after debts were paid or other distributions were made to the various respective ownership's interests, I assume is something counsel can explore with my client.
Yes, I understand that this is likely a starting point like our other documents, but I will admit 30 and 31 based on the testimony by Mr. and that he's named as an authorized seller.
Thank you very much, Your Honor.
And I'm going on the fly here.
I understand, Counselor. Hold on, there's no question pending. Do you need a break?
No, I'm just asking, I don't want to have to ask for a break. I am under medications for panic attacks sometimes, as I've mentioned to the court. I've acted, Mr. James stops screaming at the top of his lungs over documents over sales or something, because it's starting to give me a bit of anxiety, but I think I'll be okay. It's just making me a bit uneasy. Literally screaming at the top of his lungs. It's trying to, that's all I'm gonna request, please. Otherwise I might need a break.
It may cause him a reaction to hear a voice be raised. Us being lawyers, we're used to it.
I have seen counselors scream to the top of their lungs. I can't say that that is the experience that I'm having right now with Mr. Jimmerson. I understand you may be having your own individual experience. You have some diagnoses. Sir, if you do need a break, just let us know. We'll probably take a break here in a little bit for just 10 minutes for staff as well. I have a tendency to just keep going through, so note it, sir, that you may be experiencing some discomfort at this time. Let me just say though, this is a part of litigation, right?
I understand.
It's difficult, but
I'll get through it. Thank you.
And one of my old bosses told me call it trial for a reason.
Mr. Jimmerson?
Yes, Your Honor. Mr. Patrick, can you please bring up on the screen Exhibit 59? This is the quitclaim deed from November 7, 2023. Mr. Recognize this document.
You have to scroll up, sir.
Can you zoom in, Mr. Pastor, please?
What's the number again, counsel?
The Bates label is 59, is the exhibit number, Bates label 018142 through 45.
I believe that's the one that was prepared from my realtor before the proper one was sent to, prepared by, and submitted to Debbie, I think, whoever the clerk is for the county.
This reflects your 50% ownership interest in the home located at Las Vegas, Nevada 89138. Is that right?
I don't have 50% interest in the home currently.
You don't have 50% interest in that home?
No, sir.
What is your interest in that home?
0.
What did you do since November 7, 2023 with your 50% interest in the home?
I just stated I don't have 50% interest in the home.
Well, that's my point. I'm asking what you did with your 50% interest.
If I don't have 50% interest, I'm confused. How would I do something with it?
Isn't it true that as of November 7, 2023, you had a 50% interest in the home located at?
I don't believe there's anything recorded by the county that I have an interest in Midnight Melody.
Mr. Redirecting you to my question, isn't it true that as of November 7, 2023, you had a 50% ownership interest in the home located at Las Vegas, Nevada 89138?
Take it easy, counselor. No.
Your Honor, Mr. Patrick, can you scroll towards the middle of that quitclaim deed? See here it says in quitclaim deed, Mr. Patrick, you scroll just one line up, perfect. This deed is made this day of November 7, 2023 by and between the grantor, a married individual residing in Baton Rouge, Louisiana, 70817, and the grantees, an unmarried individual residing at Las Vegas, Nevada, 89138, a married individual residing at Baton Rouge, Louisiana, 70817. Did I read that correctly, sir?
You did read that document correctly.
Okay, and the property that was being conveyed was, if we can scroll Mr. Pastor down to page 2, the top of page 2. Scroll, I believe that's page 3, Mr. Patrick. Property address being conveyed is Vegas, Nevada, 89138, isn't that right?
That is property.
That's the property that was being conveyed by virtue of this deed, right?
This is not a deed, this is never filed, and nor is it the proper format.
Okay, this was the property that was the subject of this deed, is that right?
That is the property of this so-called, of this document that you protested to, yes.
Okay, and then it is signed by grantor on page 3, correct?
I don't see page 3.
Can you scroll down to page 3, Mr. Pastor? I believe that's page 4, so
I don't see signature.
that's page 2, so we gotta scroll down to page 3, Mr. Patrick. Right, it's Mr. signature on that page, is that right?
Again, I
Foundation.
need you.
It's right here.
Can you blow these
I don't
things
know
up there
whether it
across the
says
room
signature, it's
and
not
there?
notarized.
Oh, the document also does all the work there too, Your Honor. We're getting there to page 4.
Okay.
I see a signature from, yes.
Okay, and Mr. Pastor, can you scroll down to page 4, please? And you see here the notary acknowledgement, notarizing the signature on November 7, 2023, is that right?
That seems correct, yes.
And you transmitted a copy of this document to your former counsel, Marshall Wilk, isn't that right?
Marshall Wilk was never my counsel. Trevor Creel was my counsel, he never appeared.
Isn't it true Marshall Wilk appeared on November 9, 2023 on your behalf in open court?
On my behalf, but he was not my counsel of record, and he stated as such, yes.
Is it your recollection that Mr. Wilk stated that he was not your attorney?
He stated very clearly, and you actually had conversations with my actual attorney, Trevor Creel, and I was party to those, sir. And I remember giving you.
Please answer my question, Mr.
Marshall
Are
Wilk
you,
was
are
never
you
my-
testifying today that Mr. Wilk in the November 8, 2023 hearing stated to Judge Duckworth that he was not your attorney?
He was filling in for Trevor Creel.
Okay. Do you understand and do you remember the name of the law firm that employed Mr. Creel?
The Willick Law Group, as you know, because you corresponded with Trevor Creel.
And so Mr. Wilk, Marshall Wilk, appeared on your behalf as your attorney.
Trevor Creel is not available. Go ahead.
Mr. Wilk appeared on your behalf as your attorney on November 8, 2023, right?
He appeared on my behalf at hearing, yes.
Okay. Do you still maintain that he was never your lawyer?
He was not my counsel of record. He maintained, and you actually emailed my counsel of record, Trevor Creel, with all kinds of perjurious claims about me being on drugs. So you know that he was my actual attorney, and Marshall Wilk was not, sir.
Do you understand that when you make a statement like, you perjuriously communicated with my attorney, you perjuriously emailed my attorney, that implicates a crime?
Yes, sir.
Objection argumentative. Not relevant.
Overruled.
You instructed Mr. Wilk to hand a copy of this deed to me during that, or on November 8, 2023, is that right?
I had a number of documents I gave to Mr. Willick. I think that might have been one of them, yes.
Okay, so you supplied this document to Mr. Wilk?
Yes, I believe he was speaking to I don't know which of, he said he was speaking to Jim. I think he was referring to your father, but I think you as well. But yes, the whole lot of you.
So as of November 7, 2023, you had a shared or joint interest with Mr. Bennett at the home, is that right?
I did not. I had the intention to try to file, to try to have a proper one made out with this does not meet any requirements. Your own client has stated on Talking Parents that she called it fake.
Why are you giving me that look?
And what look? Your Honor,
Was it your intent to become a 50% owner in the home located?
it's my intent to try to fulfill what.
Yes or no? Was it your intent to become an owner of the home located?
At the time, yes.
Okay. And isn't it true you paid substantial sums of money in order to be an owner of that home? Isn't that right?
Objection, vague, substantial.
It's actually not true.
So when your counsel has an objection, just pause. You did answer the question.
Objection, vague, substantial.
Okay, I mean, you said no, so it's fine.
Okay. I don't remember.
That's why I said to pause when you have an objection, counsel.
Did you pay anything towards the purchase of the home located?
I was loaned a lot of money that I still owe.
Is that a yes or is that a no?
That's a no.
So you didn't contribute anything towards the purchase of that home. Is that your testimony?
You have all of my financials up to that date, Mr. Jimmerson, you know.
Sir, do
Yes,
you
sir.
know or not?
I do, and it's no. And Mr. Jimmerson knows.
Let's just keep it simple.
Okay.
Your Honor, can I publish a copy of the witness's deposition to the court for the purpose of impeachment?
Certainly.
Thank you, Judge. How do you want me to approach, Your Honor?
You can just approach Madam Clerk. Thank you, counsel.
Oh, no,
I just destroyed.
I apologize.
Desk.
No, I'm so sorry.
Okay, I got it.
I'm so
It's
sorry.
okay, counsel.
That's,
Do you need the exhibits as well?
Yes.
Okay, happy to provide those as well. Where do you go on this side of the desk?
are they all the same transcript?
They are all part of the exhibits. I'm not going to be asking him to look at the exhibits part of that deposition, at least as part of this impeachment. It's just going to be the transcript.
Transcript and exhibits. Note that it's sealed. Madam Clerk is cutting it open now to be published. And do you have a page number we'll be referring to, counsel?
Yes, Your Honor, beginning on page 135.
Mr. Page, you have a copy as well.
I don't.
You do not?
If he wants to look on, I've got some notes on mine, but there's mine that condensed.
Maybe just email it to me.
I want Mr. Page to have a copy for certain.
Deposition transcript. See what? Can I do it during a break, Your Honor, because I want to finish this examination up first.
We were going to take a break in a little bit, about 5 minutes, and then we'll try to resume and go to 12:30.
Sounds good.
Is it 135? Yeah.
Are you there, Mr. Page? Okay, 135.
Your Honor, can he read along? I apologize.
Of course.
Okay, does he, with their, sorry.
You
I
just
thought you were
have
gonna
to-
have hit, I thought, yeah. Your Honor, could he use the published copy if possible?
Of course.
Okay, I apologize, I will have an additional copy supplied.
We'll do it this way. I think we can reach. If not, John, I'll need your help.
Yeah, I know.
Thank you, sir.
Giving a deposition on January 31, 2024.
I do.
Okay. You recall that you were under oath when you gave that deposition.
I do.
Do you recall that numerous times during that deposition after we came back from breaks, I asked you if you gave us your best testimony? Remember that?
I do.
Do you remember that every time you said that you had? Is that right?
I believe I did. I did, yes.
You understood that the oath that you took during this deposition was to tell the truth, the whole truth, and nothing but the truth in response to my questions. Isn't that right?
That's correct.
Can you please open up to page 135, sir?
Yes.
Please read silently as I read aloud. From line 16 going on, we're going to go on to the next page, 136. So you get paid this incentive, $15,000. When did you close on the home purchase from Pulte? Answer, I want to say it was end of October or first day in November. Question, how did you effectuate that closing? Answer, I effectuated that closing with a cosigner and submitted a larger chunk of my savings and a large chunk of my own family's brother's savings from their own property sales. It was about nearly a $200,000 deposit. Did I read that correctly, sir? Now going to page 136. Question, from who? Answer, from me, my brother, and my family together. Question, how much money from you personally? Answer, about $140,000. What did you say, sir?
I remember that. I remember saying that, yes.
And this was in reference to the, right? So you testified under oath that the money that you paid from personally was about $140,000 for the personal home, isn't that right?
Indeed, I was instructed to do so, but otherwise I wouldn't get to see my daughter because she was telling me that you wouldn't.
Are you testifying now that you were instructed to perjure yourself by your prior counsel?
I've already stated that by Kurt Smith.
And are you telling this court now that you went along with that instruction?
I'm telling, I was confused, and I was told that just to say this because that's normal protocol for court cases by my counsel, and that I would not get to see my daughter if I didn't claim that I had more money. If I missed, and then when I started to try to clarify that, that was the one time. May I speak about this, Mr. Smith? That was the one time Kurt Smith actually bothered to intervene at all in the, and said, I'm going to stop you from sharing what your counsel told you. I think he was trying to protect her. But you have all of my financial records, sir, from multiple accounts. You know how much money I've had since, I think, 5 or 6 years back, and I can give them to you, and there is no possibility I had that amount of money.
So, Mr. Your testimony that your testimony under oath at the deposition was false, and your testimony
Yes.
today is true?
That's right. And there's financial records that I've submitted to counsel, even though counsel has refused to submit financial records of their own to, that show what I've said today is absolutely true.
Your Honor, can we then stipulate to admit those financial records into evidence? Those would be exhibits 69, 70, 71, and 72. 69 is the Bank of America checking account statements for account ending 7555. 70 is Bank of America savings account statements from account ending 6293. Exhibit 71 would be defendant statements from Capital One checking account ending 6706. And 72 is statements from Bank of America credit card ending 1158.
Also, objection, it appears this would be your client's preference.
Before I should review it before I speak, so let me, give me a brief moment to take a look here, and then I can tell you
Let's do
whether I
this.
object or not.
We're at about 11:15. Let's just take a break, and then counsel, you'll have a few minutes to review these. And then I'll note that when we return, I'll make a ruling on exhibit 69 through 72.
And the 69 through 72, and yeah, I'll
We'll take a
time to-
15-minute break, resume right at 11:30, give an extra few minutes for your review. Sir, are you excused from the stand for the break?